No. I'll have to, maybe there will be one left for me afterwards. I probably shouldn't start in on one now. I'm likely to drip it on my tie, right at the wrong time.
Okay, Tara, can we? Yeah? All right. Good afternoon. I'm Meryl Chertoff, Director of the Justice and Society Program. I'm delighted to welcome everybody here to the Aspen Institute today. We're joined today by Stuart Taylor, Brookings Non-Resident Fellow, and Peter Edelman, Faculty Director of the Center of Poverty, Inequality, and Public Policy at Georgetown University Law Center, to discuss the future of affirmative action in the courts and the classroom. I just wanted to note that a couple of people observed that the sandwiches are from Taylor Gourmet. And so I just want to give a disclaimer to Stuart. It is not his attempt to bribe you all into agreeing with his point of view. It probably, however, may reflect something subliminal in my part when I was choosing between the various menus. So I do want to welcome you all here today. We chose the topic of Stuart and his co-author Rick Sanders' book, Mismatch, because of its confluence with the Supreme Court's taking up the question of affirmative action in higher education, again this term, in the Fisher against University of Texas case, which revisits the case of Rudder, which was decided a scant 10 years ago, only 10 years into the 25-year Sandra Day O'Connor project. You will remember that Justice O'Connor's formulation in the Rudder opinion was that affirmative action was a policy that would last no more than 25 years. We are only 10 years into that, and we are revisiting it again. Stuart and his co-author's book has been widely reviewed and discussed. We thought it would be interesting in part because in the Justice and Society program every summer at Aspen, we run a seminar. We've got one of our alumni here with us today, Pandit Rai, and she will recall that Lee Shore's article called the Sandra Day O'Connor Project and what it will take to fulfill that vision is one of our readings in the book. Oh, we have Mike Spivey also, another alum. So we thought that it would be interesting to take a look at the Mismatch book and the discussions about the Fisher case through that prism. And so I do want to act like a law professor, which is one of my other hats, to just kind of do a very, very brief setup about the way that we look at affirmative action during the summer seminar. And we look at it in terms of the two poles that we discussed in the summer seminar, the issue of justice and fairness, and the issue of utility. And so when we're thinking about affirmative action, as we go through the discussion today, I was going to put it on the whiteboard like a good law professor, but they told me that that was not going to look good when they filmed. So we'll just sort of say we think about justice in terms of justice to groups and in terms of justice to individuals. And on affirmative action, there is pro and con on other sides. So if you were setting up a grid, you could kind of think of there being four arguments. We also talk about utility, which is the what works kind of thing. And we talk about what works for individual, what works for groups, and again, in affirmative action, there's pro and con on either side of it. So if I can take a shot at the claim in Mismatch is sort of narrow and most focused claim is that affirmative action doesn't work, that is, it is lacking in utility for the people who it was designed to help, that is, African American and Latino students. So it's a question of utility as to individuals. And that at its narrowest and most focus, I think, is the claim that the book is making. But I'm going to put the first question to Professor Edelman, which is that if we accept, and I know it is a big if, and there have been at least two amicus briefs filed in the Fisher case that contest the statistics that Sander and Taylor rely on. if we were to accept for the moment that their statistics are correct, is there still an argument, notwithstanding the challenge to utility individual cases, that affirmative action in higher education admissions is still a positive good that we want to continue? Professor?
That's a policy question.
Okay.
I think that I certainly understand that the arguments that Stuart Taylor and his co-author make are based in research that they've done and that they rely on. And of course, there is a pile, here's a little bit of it, of academic dispute about that. And indeed, in the book, Stuart and his co-author answer, because the book is very up to date, have their answers. As you said, accepting that it's correct, what do I think? Well, the basic point, I guess I would say, is two things. One is that we are far from done in creating racial justice and ending discrimination based on race in our country. That is a task, that is a statement with which is disputed, at least in terms of its constitutional significance. I think that when the court started to dismantle the desegregation decrees, starting with Dowell, going through DeKalb County, and so on, and Justice Marshall was very eloquent in his dissent in the Dowell case. He said, we're not done. And so I think that's also true when it comes to this question. Now, I do think that the whole dispute over whatever our terminology is, I think probably Stuart and I agree that we don't much like affirmative action as a term, although maybe for not the same reasons. But in any case, continuing to search for ways to make up for past discrimination in higher education. Secondly, because Grutter has made it the law of the land, to be able to take race into account as part of an effort at diversity. I would have gone in a different direction if I had a vote going back into the cases like Croson and Adirond, and although each one of them has particularly Croson has facts that are troubling to say the least, but in any case also the capital of the old Confederacy. The direction that the court has been taking, particularly since Justice O'Connor left the court, is one that is one of dismantling the many of the constitutional protections and doctrines that we've had. As I said, starting with the dismantling of the school desegregation remedies. So I think we're not done, and at the same time, this can't be our lot as a country. It's unacceptable. The idea of 25 years, I thought was Justice O'Connor's 25 years. I thought was too short, given our history and what we have to do. When Justice Marshall told one of his colleagues, as Stuart and Professor Sanders say in the book, that it would take 100 years. I have to say I gulped if he said that. But it was perhaps his pessimism about how well we do about these things. The real challenge here is to get out from under this discussion, is to not need this. What is happening, if I could say something a little bit, what should I say, aggressive, but not to you. And that is that I think that what we've done with affirmative action is that we are opening the stable doors after half the horses have been asphyxiated. The children are being born in this country every day, black and white, but disproportionately African American, Latino, people of color, young people, children of color, with 15 strikes against them. And we are not doing what we should be doing from well, in many cases before the point of conception, but certainly from the point of birth. And we need to change our focus so that we are not continuing to be faced with the idea that we would even talk about different outcomes in policy that relate to past discrimination against African Americans.
Stuart, are you making an argument about fairness, or are you making an argument about utility? How do you come to this?
We're making mainly an argument about utility. Let me begin by thanking you, Meryl, and the Aspen Institute for giving me an opportunity to discuss the Stuart Taylor book in such distinguished company, including Peter and all of you. But we're making primarily an argument about utility. I think there are powerful arguments from fairness on both sides of the racial preference equation. I prefer the term racial preference for the same reason I prefer the term athlete preference, legacy preference, veterans preference. That's what it is. It's a preference. And I don't like the term affirmative action because I think it's ambiguous and euphemistic. But, you know, fairness, there's an interesting new article showing pretty convincingly that the old Jewish quotas of the 1920s have been revived in the form of Asian quotas of the current era, that virtually all the top universities in the country systematically prefer all other racial groups over Asians, which seems to go almost unnoticed. But that's not really our focus. And I agree with, I think, the great bulk of what Peter just said. The one qualifier I might add to that is a quotation from my dear friend William Coleman, who was sitting by Thurgood Marshall's side when he re-argued Brown versus Board of Education, was for many years head of the NAACP Legal Defense and Educational Fund, and many other distinctions. Bill's memoir contains the following quote: "Today, race in and of itself is usually not an impediment to success at the highest levels of our society, or at any level for that matter." And he goes on in some detail to, I think, go a long way toward endorsing something close to the remedies we endorse in our book, or one of them. But let me start with two propositions about racial preferences in university admissions that may seem counterintuitive. You alluded to one of them, and two proposed reforms that I think should not be controversial. First proposition, which, Meryl, you touched on, is that racial preferences harm many and perhaps even most of the minority students they're intended to help by bringing them without warning into highly competitive settings where they are likely to struggle academically and become demoralized. And nobody tells them this is what they're likely to get into. They're told, oh, you're going to do fine. But an outpouring of social science evidence shows that lots of them are not doing fine, and that the mismatch problem, academic mismatch, largely explains some phenomena why African American students tend to cluster toward the bottom 20% of the class, half of them in the bottom 20% of the class in undergraduate school, in the bottom 10% of the class in law school, why most who aspire to be science majors when they enter college end up fleeing to softer courses, far out of proportion to other racial groups, why most law graduates flunk the bar exam at twice the rate of white law graduates who entered law school with similar academic credentials, and why surveys show that black university students lack academic self-confidence to a larger degree than others. Not to mention, and there's less scientific evidence on this, what I think is the disincentive effect of racial preferences on those who expect to receive them. The second counterintuitive proposition is that the current racial preference regime in the universities makes economic inequality worse, not better. That is, the racial preference regime systematically favors relatively well-off African American and Hispanic American students over working class and low-income Asian and white students who are academically better qualified and less affluent. As for our proposed reforms, which I think should not be controversial, the first is to require that universities' race-conscious admissions programs be totally transparent, that all data, with of course due protections for privacy, but all data bearing on how large the racial preferences are, how they operate, whether they operate more or less automatically or whether things are as holistic as the universities suggest they are, and how people perform who are admitted with academic credentials well below the median of their class. All those data should be public as part of the burden of proof that a university should have to sustain the constitutionality of racial preferences, which after all, under Supreme Court doctrine, are presumptively unconstitutional unless the universities can prove that they are narrowly tailored to serve a compelling interest, in this case, diversity. A friend of mine who's sitting here coined the phrase, secret preferences can't possibly be narrow tailoring, which I adopted and plagiarized for purposes of the book. The second remedy would be to require that universities give priority to socioeconomic equality over racial identity, in the sense that their racial preferences can be no larger than their preferences based on socioeconomic class, than preferences designed to correct really the scandalous focus of the universities, the selective universities' attention on the top 25% and the top 10% of the socioeconomic curve. As for the proposals, although there have been critiques of some of the evidence on which we rely for mismatch, as to these proposals, I've never heard a coherent objection to either.
Peter, what about this question of economic status or poverty as potentially a substitute for race-based preferences, action, admissions, criteria? How would you disagree with Stuart on that?
Really only partially. That is to say, and I won't repeat what I said before, I think if I had a vote, we're not done with efforts that are based on past discrimination. And in terms of diversity, that's more complicated, but I do support Grutter and certainly hope that Grutter is not going to be overruled. Maybe we'll talk about that. But I'm very interested in the question of taking economic status into account in college and university and admissions more, I think, well, probably at the graduate school level as well, but certainly the undergraduate. But I think that you can't do that in isolation, and so it's important to look and see what the experience has been, and there is information about the 10% in Texas, but as we all know, and as you say in the book with some of the stories that you tell, the young man from Syracuse who goes to Colgate, there are too many. One of the things that's a problem here is this education that kids who are from low-income families are getting, and therefore how good the preparation is to go to college, and so the simple solutions just don't work. And you got to get back to the beginning. It starts with early childhood. If kids aren't ready for school by the time they're 5, you're in deep trouble. And then to the extent that we do well with early childhood, I won't take you through, but it's obvious, K through 12, etc. So yes, I think that we should be, you make the point that colleges and universities should be reaching much more aggressively based on SES, and I absolutely agree with that. But it is tough when you go to a crummy high school to make the jump. And now, on the other hand, if we get down into the details, some of your argument makes some sense just in terms of based on the level of preparation, not the level of ultimate performance. If kids go to community college, they can go get a transfer along the way. That's just sort of common sense. 4-year colleges in many cases need to do a heck of a lot more than they're doing to support kids and provide, make sure that they can do the work when they're there, even though their basic ability is fine. So I think the answer is yes. I'm very interested, and my colleague Cheryl Cashin is working on some ideas that go further than looking at the question of income levels. And you do talk about SES, so you're talking about more than that. But looking at place, kids who come up in areas of concentrated poverty, looking at family status, where you've had a single mom, you very likely have very low wage jobs there, and so that's connected to poverty as well. Looking at assets and wealth as well as that. So I want to see that developed and see where that takes us. But I'm very interested in that.
Stuart, what about the pool? More young African American men are bound for prison than are bound for university, and your book doesn't talk at all about where that pool is coming from and some of the problems that arise well before even the college application process. Why was that choice made? Obviously, you can't cover everything, but why was that choice made, and how would you respond to Peter?
Well, Chapter 17 of our book is entirely about the problems of K-12 education and why we end up with a gigantic test score gap between African American kids, Hispanic American kids, white kids, Asian kids coming out of high school, and what might be done about it. And the facts are pretty tough. I think we do address the pool issue. The average black 12th grader has learned as much as the average white 8th grader, according to undisputed studies by the National Assessment of Educational Progress. The percentage of blacks who are in the very top tier of, say, SAT scores, let's say 1,500 and up on a 1,600 scale, which is where the top colleges get most of their students, is tiny. Something like there's a large percentage of blacks who go on to college, larger, by the way, than the percentage of whites from similar income groups, but not who graduate, and you can see the difference in those test scores. Something like 1 or 2% of the top test score tier are blacks, even though 14 or so % of the people taking the SATs are blacks. Why is this? As Peter says, there's a difference in schooling. But the best research I've said is suggests that the problem goes beyond that. Best research I've seen is by a Harvard economist named Roland Fryer, who happens to be black and has not been called a conservative as far as I know. He says that the differences, racial gaps in learning, become apparent by age 2, that they become large before children enter kindergarten, that they tend to, he attributes them mainly to parenting practices and peer group influences, the stigma against acting white, the question whether you spend time reading to your child or parking the child in front of the television. Roland Fryer and I think most other researchers I've seen attribute the gap at the graduation from high school level more to those factors than to differences in schools. White and black children going to the same schools from similar income categories. There's a huge gap there too. And I think this is all explains why we have the affirmative action issue. There wouldn't be any issue if you didn't have racial gaps coming out of high school. And what do we do about it? We need not just an improvement, we need a revolution in K12 education, and maybe in pre-K education too, in order to address this gap. And racial preferences in university admissions, I submit, are a Band-Aid that takes, of course, most poor kids aren't in that game at all. Most poor kids are nowhere close to getting into a selective university, no matter how large the preference might be. When I speak of socioeconomic preferences, I'm thinking less of poor kids who are often semi-illiterate than, say, the children of taxi drivers, dry cleaners, factory workers. There are many children of that kind, white, Asian, and black and Hispanic, who are not going to college because the colleges really aren't very interested in having them, even though their academic credentials are better than those of many of the black students who are accepted via racial preferences. But on the pipeline problem, that's the biggest problem, and we admit in our chapter that the solution that many people who have studied these problems, the K-12 problem more deeply than we have for many years proposed many solutions. None have created much progress. The test score gaps between whites and blacks coming out of high school have not narrowed appreciably in the last 20 years. They were narrowing for the previous 15 or 20 years, starting in the late 1980s. They stopped narrowing, and so Justice O'Connor's 25-year hope was based on the idea that, well, the gaps will narrow, and within 25 years we won't have to worry about this anymore. Well, that was an illusion when she said it, and it's clearly an illusion now because we're 9 years into this, and the gaps have not narrowed, 9 years into the 25. And by the way, we're 9 years into the 25, and as far as I know, not one university in the country has moved 1 inch in the direction of preparing to phase out racial preferences within 25 years.
Well, I'd like us to get into the question of the two cases because I want to leave plenty of time for discussion amongst the group as a whole here. The Rudder case obviously was the first examination of this, and when you look at the O'Connor language, there's a delightful discussion about the advantages of racial preferences for white students because it's going to create a more diverse campus environment that's going to have everybody living together and working together, and so that will be of great benefit to the white students on those campuses. When we look at the decision of the court to take the Fisher case and to revisit essentially a similar policy at the University of Texas that was examined in Rudder 10 years ago, what do we make of this? Why has the court jumped in so quickly to revisit this? And I know that Stuart, you've talked about it in the book, but Peter, maybe we'll start with you.
We have a different justice on the court now from who was on the court when Rudder was decided. I think that's about it.
Actually, there's 4, aren't there?
It's one who counts.
Right. I think I know the one you
purpose.
mean, but I'll leave it to you for now.
You know, you had partial birth abortion, and then you had partial birth abortion, and there was one difference of one person at that point in time, and you got a different result. And I certainly hope that there's enough respect for stare decisis on this court so that it would not overrule Rudder after such a short period of time. But I'm not going to put down a bet on that.
I don't doubt that as a matter of realpolitik, the fact that we now have Justice Alito having replaced Justice O'Connor and various other appointments that didn't produce an ideological shift produces a large ideological shift that probably explains why the court took the case. I think they were right to take the case because I think there are good reasons to take it apart from who's on the court. One is what I said a moment ago. The idea has always been that these were temporary remedies and that it would be unconstitutional to set them up as perpetual, as a perpetual thing, these racial preferences. That's why Justice O'Connor said 25 years. That was perhaps dictum, the 25 years, but it was holding to say these cannot be perpetual. There has to be an ending point. And they started in the late 60s, so Justice, we're not. I think that most supporters of the preferences today would like to have many more than the 100 years that Justice Marshall said they'd need. Also, the Grutter decision laid down a number of principles to restrain expansion and extension of racial preferences that it didn't really enforce. And I think maybe its time has come to enforce them. They cannot be permanent. Racial preferences cannot be automatic. It cannot be the deciding factor in any student's application. Racial preferences cannot be the first resort. They should be the last resort in terms of ways to find diversity. And other limiting principles that Justice O'Connor laid down that I think are being flagrantly violated by universities all over the country, including the University of Texas. And I think it was wise of the court, if realpolitiki wise, to say, it's time we had another look at this. Also, one practical factor is it is very hard to get a case through the courts challenging these practices. The only restraint on the university's impulse to extend racial preferences forever is individual lawsuits. And individual lawsuits are very hard to bring. If you didn't get into college, you probably don't want to spend the next few years when you're in some other college. You didn't get into the college you wanted, you got into another college, you're going to go live your life. Most people don't want to spend their years litigating. And in fact, it takes a little bit of work for opponents of racial preferences to create these cases. Abigail Fisher was found by racial preference opponents who were looking for someone who was ready to sue. There aren't many people like that. She sued, and so this will be perhaps one of the very few opportunities the courts will have to exercise their policing function.
Can I say just a word more? A word about Justice Kennedy. He has said a number of times in these kinds of cases, he's never voted to uphold any affirmative action policy or program. He keeps writing these concurrences, as he did in Parents Involved and what he said in Rudder as well. So that I call him a little less than strict in theory, but fatal in fact. And I would hope that I'm wrong, that the time has come where he would distinguish Rudder and say that the particular arrangement in Texas was on top of the 10% and so on, and that therefore it's all right. But at the very least that he would say, this one didn't make it either, but I'm not overruling anything, and that he's the fifth vote for a narrower decision. So just to put that in as one of the possibilities that turns on what his thinking is. The other thing I would say is that I do have I don't like the word preference either, and I don't like preferences. I think that what we should be doing, and you just said what the limitations are that the court has laid down, starting from Bakke and repeated in Rudder, that is what you use the term, and I think many people do, I guess I would, holistic. I think you're a little unenthusiastic about that, but I would say that...
Valid in theory, but phony in fact.
Yeah, there you go. That's the Taylor position. And unfortunately, I'm afraid that there's too many places where that's correct. But my experience at Georgetown with our admissions process is I think it is genuinely holistic. And I've sat on the admissions committee for many years, and we do take race into account in the sense that we take many things into account. And I don't know if I could count up the number of factors or whether we've counted up the number of factors. But we read every file, and we have more applications than any law school in the country. And we have our students across the board. We make admissions mistakes, I'll tell you that, but we're very equal opportunity in that regard. Nobody does it perfectly, but I have 5 African American students in my poverty seminar right now, apropos of the point that you made before, Meryl. And just to say the obvious, it makes a total difference in terms of and also Latino students, also people who are white and came from low-income circumstances, all of that. If I had a bunch of white, upper-middle class, private school educated, et cetera, it'd be just a completely, totally different conversation. So what she said about that is right.
No, it might be relevant here, Meryl, if I may, to talk for a minute about how my co-author, Rick Sander, started down the road that led to this book, which he asked me to join him on, but it was his project originally. Rick's passion is civil rights. He's quite liberal. His first wife was black. His son, who just graduated from college, was classified as black. And his first job, or one of his first jobs, was community organizer in the south side of Chicago, which may sound familiar. When he went to teach at UCLA Law School, his first impression was that he's in this diversity paradise where there was lots of racial diversity, and people seemed to get along pretty well. And then he noticed first that semester after semester, the black kids in his class clustered at the bottom of the class. You grade blind, and then you get to open and see who did what. The black kids clustered at the bottom. He asked the admissions director, gee, what's going on? And the admissions director said, well, of course they cluster at the bottom. We have 2 separate admission systems that barely overlap at all. The presumptive admit level for black kids is below the presumptive reject level for white kids. Then Rick looked into bar exam performance. About 90% of the white kids passed the bar exam, about 50% of the black kids on their first try. Then he compared the black percentage at UCLA to the percentage of people at Pepperdine Law School and some other local law schools which are much less selective than UCLA, but their students were passing the bar at higher levels than the black students at UCLA. Then he got a hold of large databases that showed him that these phenomena were national, not local phenomena. It may not operate the same place everywhere. I certainly defer to Peter on how things work at Georgetown. And that he got, and I think, frankly, what I thought was the most dramatic thing he found in this research, which I mentioned previously, is the black bar flunk rate is about 4 times the white bar flunk rate. Now that is skewed to some extent by differences in entering credentials. So you can do statistical adjustments and you compare black and white students with similar credentials when they enter law school. There's every reason to think that they would do similarly in law school and similarly on the bar exam in large averages. And even in that group, the black bar flunk rate is twice the white bar flunk rate. And by the way, the percentage of blacks who enter law school who ever become lawyers is below 50%, according to Rick's research. So why do you have this difference in bar flunk rates between different racial groups of students who enter with similar credentials? Our theory, Rick's theory, is that they're going to different law schools. The blacks with similar credentials who are going to, say, Georgetown, are competing against whites who are going to, say, American University or someplace less selective, and they're learning less. The ones who are getting large preferences are actually learning less, are having their academic appetites, let's say, dulled by the experience of being way behind the rest of the class, and that this is reflected in bar passage rates. So that's where this starts. And
So,
the reason,
so this is why you're calling it mismatch. That's the theory, is that's why that it's a mismatch.
That's right. And the reason for the focus on law school is partly, in the early research, is partly it was Rick's, that was where Rick was, but it's partly that there is a bar exam. In most areas of, in undergraduate school, they don't have a big exam when you come out that shows how much you learned. But as noted in the book, others have done a lot of research on the undergraduate level with results similar to what Rick found in law schools.
Well, I think that you're probably going to find a lot of disagreement in the room, and so maybe this is an opportune moment to open it up to questions, comments. Yes, Gary.
I don't know if this is working or not.
If you press
Yeah,
on the button and it ought to.
I tried, but I think it's
Nope, okay.
dead. But I'm Garrett Mitchell, and I write the Mitchell Report. And I want to start in a slightly different place, and that is Peter Edelman made two interesting comments that we could just sort of make assumptions about. But I would like to see if you could just, as they say, drill down a little bit on both of them to give us a better feeling for what happens. The two things that I'm talking about were, you talk about your work on the admissions committee, and you say, yes, we take that into account. Of course, we take a lot of things into account. I'd be interested to know what's it like when you take that into account. What does that mean? And the second was when you were talking about the course you're teaching on poverty, and that if you have African Americans, Latinos, or Caucasians who have come from different economic strata than if you had the class full of graduates of St. Grottle sects. That's a very different conversation. How is it different? I mean, what's the? I'm just interested in some sort of almost touchy-feely stuff of what happens.
Well, and I should say another thing that I would add to the list, to be fair with some of the young people who come from privilege, is that people who take my poverty seminar are interested in doing something about poverty, and many of them have been out of school for 2 or 3 years and have done things out there where they've worked. They've been in Teach for America. They've worked for the local aid as a legal aid, as a paralegal. All different kinds of things that have given them some connection in one way or another to the what the world is like for people, low-income people and children. So all of these are, in one way or another, perspectives about things that bear on questions of poverty. And poverty is disproportionately racial in our country, as we know. So someone who's African American and has not been a low-income person himself or herself still has a perspective that's relevant. So it's a combination of the life circumstances of the person or their understanding from the perspective of their own race or ethnicity that adds one thing or another to the discussion. Whether it's about, as we go through the course, about issues of low-wage work, issues of education, issues child welfare, I mean, all different kinds of things, juvenile justice, things that we talk about, where one way or another somebody in the room has some perspective that bears on it. So that's on that. The first question you ask, I have to say it's hard because we don't have a specific anything written down, and we take, so nobody says, that I've ever heard. Now, I haven't, the committee only makes recommendations, so I haven't sat in the admissions office where they're making the final decision. But it's really kind of intuitive in terms of all the different aspects of, well, have they done something for the world, for the community? It's a public interest. We think that's very important. Have they surmounted barriers of some kind in their lives, including income, but maybe other kinds of things, a disability or something else? So how we take all of these things into account, I can't give you a measure. We have one pile of applicants, apropos of what Stuart says or Professor Sanders says about UCLA. We have one pile of applicants. We go through them, and it's really impossible to quantify
I wasn't looking for metrics.
Yeah. Does that help you?
Yeah.
Good.
Peter, can I just jump in and as a point of privilege, for many, many years, I have been an alumni interview for my own college. And the most interesting question, which I ask every student that I interview, is what's the most significant challenge you've had to overcome in your life? And I have heard some unbelievable stories from young people applying to an Ivy League college of challenges they've had to overcome in their life. And I contrast that to young people who the biggest challenge that they've had is, they had an injury during the sports season, they had to sit out a few weeks, and that was really tough, So when you think about holistic ways of looking at the overcoming challenge and developing that kind of strength of character, certainly is significant factor. Certainly that I look at, and I assume that is looked in the law school admission
and we absolutely turn down people with very high LSATs and very high GPAs because we are, in a way that ultimately can't be quantified, looking at the whole person.
There's a question about research universities. They're the envy of the world, and one is because of the partnership with the U.S. government. Two would be the alumni support. People hear me? All right. Second is the alumni.
Can you identify yourself? Sorry.
Sure. Jim Rowe, used to work in higher education, and I get at Georgetown and at Princeton. There's no question that somebody who was the child of a parent who went there is going to get a second look. And if we're talking about we're not in favor of this preference or that preference, what do the two of you think about? Should we change that kind of preference? That clearly is going on at every research university today.
Legacy preference?
Yes.
I'll start out if that's okay. I oppose legacy preferences. I came to oppose them, frankly, because I hadn't given them much thought until I began writing about racial preferences, because it seemed to me that you couldn't be a critic of racial preferences and be a supporter of legacy preferences at the same time without having a lot of explaining to do. But I will say that legacy preferences, I think, although they may actually affect more people, do not create a mismatch problem as far as we know. There isn't a whole lot of research into how they work, but such research as I've seen, and I looked hard, suggests that the legacy preferences are a small finger on the scales. They're not insignificant, but they do not bring in people who are a big academic gap below the rest of the class. Racial preferences do that. Preferences for really rich donors sometimes do that, although there aren't many of those people, and maybe football and basketball players do that. But I think the other thing about legacy preferences is there really isn't any constitutional case law that provides a basis for attacking them in the courts.
I live in the real world. Try to, anyway.
Jonathan Roush, Brookings Institution, National Journal Atlantic, writer, friend of Stuart. So it's one thing to say that racial preferences fail as a matter of policy, and it's another to say that the court should write into the Constitution that no university should ever be able to use them, no matter how much a university feels, for example, it might improve the atmosphere at the university or diversify the student body or make it easier for Peter Edelman to teach the kind of course he thinks he needs to teach. if we stipulate that the court is not in a position to micromanage the enforcement of its edicts and will never be in a position to look into what particular universities are doing and correct them, should the court step in and constitutionally outlaw this kind of policy?
2 points, John. Well, 3 points. One, we don't advocate that they constitutionally outlaw it. We don't rule out that might be necessary if reform proves impossible. But that's not what we're arguing for, and there are a lot of good reasons to be concerned. It would be a very bold act of judicial power. But number two, there is precedent that points directly towards putting limits, at least, on the use of racial preferences. In Rudder itself, Justice O'Connor said verbatim that it is unconstitutional to use race-conscious admissions in a way that causes undue harm to any racial group. I submit that the mismatch evidence goes a long way towards establishing that these racial preferences as used, the large ones, do undue harm to every racial group. And if they're doing harm to every racial group, it's almost by definition undue. Third, you're right about the court having trouble micromanaging. That's one reason I think that our remedies are attractive. One, transparency would allow the political system to address this problem in a responsible way. It would be a consumer protection measure for students so that they would know what they're getting into. And as for racial preferences being no larger than socioeconomic preferences, that would be a bolder remedy, but very administrable, much more administrable, I think, than, hey, it's too large. I think the biggest problem with racial preference is not that they exist, it's how large they are, and this would be a way of limiting that.
My answer, not surprisingly, is no. I would not have the court ban appropriate policy, put it that way. You sort of say that what President Clinton did was sort of obvious, right? There's a point there where, mend it and don't end it. And you say, well, everybody agrees with that. No quotas. You don't take anybody in who's not qualified. That's the heart of it. I think that's actually quite important because people still do talk about quotas, and indeed your indictment on preferences is close to an indictment of quotas as you see it, as they're actually being applied, implemented. I think that the whole diversity question in relation to race is a little bit incoherent because it sort of mixes apples and oranges. It says there's all these other ways that there could be diversity, which are sort of qualitatively different. Having cello players and hockey players and maybe even people who gave a lot of money, or their parents did, and so on. And then there's this question of race that gets into the list in sort of an implicit way, because we actually are, even though we're not saying it, dealing with past discrimination that's not, or even present discrimination societally, that we're not done with, hence the 25 years. So I think when we drill down on that, it's a little more complicated than sort of the word diversity on the surface. But that said, however we do the policy, the court said way back in Swan in the 1970s that the remedies for segregated schools would have a time frame on them. I mean, this is when Justice O'Connor said 25 years. That wasn't the first time the court had said something like that. It was the first time they put a specific amount of years out there. But the concept that we're only doing this until we get to the point where we really don't need it anymore, that's correct. And so our aim, all of us, should be to get to that point as soon as we can. And that brings me back beyond your question to what I said and Stuart says as well, in terms of really an all-out effort that makes us understand not only are there huge questions of poverty in this country that should not be there, but that they are heavily, disproportionately questions of race and ethnicity. So just to reiterate that part of it.
Peter, I'd like to ask you also to respond a little bit to Stuart's point about transparency, which you and I both have Georgetown affiliations, and there's a big question going on now more generally on the question of law students as consumers and the what that degree buys you in the marketplace. So is transparency in terms of that data and how well you are prepared to actually get a job with that degree, is that a good idea, whether it's in a racial context or not in a racial context?
Well, yes, as long as you're not dealing with privacy issues that you're talking about individual people. But I think we ought to know relevant information about what universities are doing. I mean, I think would be there are probably some things that are happening that some institutions would rather not put out there, but probably be better if we knew.
Well, could I?
If I was a dean, I'd probably say something different.
Could I jump in there?
Sure.
Oh gosh, I lost my train of thought. I'm sorry. Oh yes, I think it's no accident that not one university in the country ever, as far as I know, has made public the kind of data that I think should be made public. Some have done so involuntarily through freedom of information requests and litigation. And we learned interesting things about how holistic admissions works in the University of Michigan cases. The University of Michigan undergraduate school had a point system, 20 points if you're black or Hispanic, 20 points if you get an A average instead of a B average. Those were among the criteria. In other words, the way the system works was as though you just added a full grade point to the GPA of every black applicant for purposes of, and Hispanic, for purposes of comparison. The Supreme Court thought that was too blatant, too bald. They struck that down in the Gratz case. In the Rudder case, they said, now we have this nice holistic system, no point system, and they upheld that. Guess what? Research done both before and after the decision shows that the preferences used by the University of Michigan Law School, the ones that were upheld, were larger than the preferences used by the undergraduate school that were struck down. And I submit that it's the size that matters, not whether you call it a quota or a point system. And therefore, they upheld the worst of the two systems and struck down the one that at least was involuntarily honest. I'll stop there.
I'm Stephen Black, former sometime lawyer. This is really for Peter Edelman. It seemed to me that the thing that was new and important.
I don't know that that's working.
We can hear you.
Okay.
The thing that was new and important about Stuart's book was the evaluation of the performance, the consequences of the preferences in the schools, and the fact that the preferred groups seem to do so disproportionately badly, and the consequences of that to them. That was, to me, what was really outstanding in this book. And so my question to you is, do you simply reject that data, or do you say, well, some of it may be true, but because of the societal issues that you've spoken so eloquently about, it really doesn't matter?
No, I don't think I would actually say either one of those things. The question of continuing what's permitted constitutionally may be different as time passes from what is the appropriate policy. That's true about many things. And as to the heart of the book, I have to say, with all respect, that this is highly disputed. This is highly disputed. And I'm very clear in saying to you that Stuart and Professor Sander answer these things in the book. But I can assure you that there would be a rebuttal to that if we had some of the authors of some of the papers in the room. I mean, I'll just read you, if I may, from the American Education Research Association amicus brief. Just a minute. These arguments receive the support of few researchers, and the bulk of the scant research supporting these claims has been published without peer review, has been widely criticized by peer scientists, and has been contradicted by better designed and more recent research. Multiple studies confirm that purported problems of stigma due to race-conscious admissions and the educational harms resulting from the so-called mismatch of minority students at selective institutions have not been established by the studies said to prove them, and indeed are regularly contradicted by sounder and more widely accepted research. Now, I'm not going to adjudicate that question. I'm just telling you, and he will, of course he will. But I want to
briefly.
Sure, and I respect that. But this you have to understand. I'm sure you do that this is highly disputed.
I would concede that that some of it is highly disputed by highly credentialed academics, people with world-class names. I don't disparage their names. I only disparage their work. And you might ask at the beginning, well, why would a bunch of highly credentialed people say things that don't stand up?
Yeah.
Well, there is no better way to endear yourself to your leadership in the university world today than to come to the barricades in defense of affirmative action. That is number one. And there is no better way to make yourself tenure-proof than to be a critic of affirmative action. I'm afraid Rick Sanders, who got tenure before he became as scandalous as he is now, might not be able to get tenure again. But the brief that Peter reads says what it says, but in context, it's the only specifics other than not peer-reviewed. Guess what? A lot of the work we're relying on was peer-reviewed. Not published. Guess what? A lot of it was published, has been published. But the bulk of it is used by long-time attackers on Rick Sanders' work on law school. They do not challenge any of the propositions I've stated today. They only challenge the last mile, which is Sanders' argument that these students would be better off at less prestigious law schools. They don't challenge that half of black law students are in the bottom 10% of the class. They don't challenge the bar flunk rate statistics that I mentioned earlier. They don't challenge that there are huge grade gaps and graduation gaps. They don't challenge the California data showing that graduation at all levels and grades improved when preferences were abolished. And they don't even mention about 3/4 of the evidence in the book, which is science mismatch, which I've talked about, kids dropping out of science, kids who wanted to be professors giving up on it, similar kids at less prestigious universities in higher percentages going forward with it. They don't challenge the data on loss of academic self-confidence among black kids at prestigious universities. They just ignore all this and then file a brief purporting to have refuted it. Well, it's easy to refute something by picking one of several points, beating up on that one dishonestly, and ignoring the other ones.
Gentleman in the back.
John Wilson, outgoing head of the White House Initiative on HBCUs and incoming president of Morehouse College, starting in February. Thank you. But I come to the whole issue of mismatch with a perspective on HBCUs. I don't challenge the data that you have in that book either. I'm not sure there's a basis for challenging a whole lot of it. But my experience at Morehouse as a student, undergraduate, and at Harvard as a graduate student, and at MIT where I spent the first 16 years of my career, points to something that I don't think you get at in the book, and I think makes an enormous difference. It kind of explains what's going on at UMBC and explains to a great deal the history of HBCUs, and that is the emphasis upon values, the emphasis upon drive, the emphasis upon nurturing and encouragement. That can close gaps because it can increase the emphasis in a student on putting in the time and sort of changing the mindset that you bring to the study in the first place. And you find that kind of emphasis at a lot of HBCUs and a lot of places like UMBC, and you don't find it in the places that you focus on in your study. And I think that that could be an enormous difference. The other point I'll make there, I'd like your opinion about, is there is at the root of all this, and you do acknowledge this in the book, this stems way back before you even get to law school. There is an education gap, and it's been there for a long time. Exacerbating that education gap, there is an achievement gap. And this explains a lot of the orientation of the current Department of Education led by Arne Duncan, who's trying to get at the education gap. The achievement gap is on the value side, all right? I do think it is incumbent upon the federal government to try to close the education gap, all right? That is the fact that African American and other minority students don't have a shot because what they're offered in their K-12 experience doesn't come close to what other students who are in K-12 are offered, which makes them far more competitive coming out of the K-12 system. The gap that can be closed is the achievement gap. I'm not sure you get at that either. So I'm dealing with two things here. One, in the K-12 level, where you have the achievement gap, which is not being broached effectively because structural reasons, infrastructural reasons. And then you have the gap that occurs in colleges where a lot of HBCUs, not all of them, and places like UMBC are paying attention to what we used to call at MIT the X factor. There is an effort issue that if you get a hold of a kid's values as soon as they come in and give them a sense of a pathway through just through effort and the right kind of assistance framework, they can achieve just like everybody else.
Go ahead.
I agree with that. I applaud that. I was leafing through the book looking for a quotation. I couldn't find it, so I'll go from memory. An HBCU professor and administrator complained rather bitterly that by taking in some of the strong black science prospects to universities where they were overmatched by better prepared whites and Asians, instead of them going to, say, HBCUs, you're losing lots of potential black PhDs. And I think the numbers are stunning on the high percentage of PhDs and other leaders who have come out of HBCUs. So I applaud the work the HBCUs are doing. I think there's something of a debate as to whether HBCU students are outperforming their entering credentials compared to students at highly selective places because there's no gap, they're not facing a gap with their classmates, or whether it's because of a more nurturing environment, being surrounded by other African Americans. I'd be interested in your view on that. But as to K-12, that's where the big problems are. And I think this administration has done some great work on trying to attack the teacher issues and trying to break the grip of trying to say, yes, you can fire bad teachers, yes, you do need to evaluate teachers, yes, you should reward good teachers. This administration has been strong on that. I lament what they've said about discipline, which is disparities in school discipline are presumptively discriminatory, and therefore they're basically attacking efforts to discipline children who are disruptive in class, and I think the people that hurts are the black kids who sitting there want to learn. But I'm a little off topic now.
First, congratulations, Dr. Wilson. That's quite wonderful. I would just say that I obviously completely credit, and I know this in a personal way as well, about the historically black colleges and those strengths that you talk about. I think the challenge is to make sure that predominantly white campuses do their job in terms of all different kinds of the different backgrounds of people who come in who need or could use anyway support in a variety of ways, not just narrowly academic. So I think that part of the challenge here is that in terms of some of what's happened. I will say, in terms of my experience again at Georgetown Law School, which is obviously anecdotal, but it's my direct experience, I think that we do a pretty good job. I think we're a learning environment that's supportive of everyone, and I think students of color would say that. So I think that I don't think it's a matter of we're better, they're better, whatever it is. I think that these are both very, very important. And certainly Morehouse College, there's a person from Spelman who lives in my house. I live in her house.
Can I just say one more thing? I really want to point to a difference there. You could see the kind of gap that you point to, Stuart, and you could say one of two things. You could say, these kids don't belong here. Or you could say, it's the responsibility of my institution to figure out what's going on and close this gap. That's what I hear you saying about Georgetown, Peter, and that's the way we looked at it at MIT, that we have a responsibility to help to close this gap. Now, one final thing, pardon me, Meryl. There's a new economy now, all right? And it is far more difficult to prepare kids, especially coming out of K-12 and in the college experience, for this economy. Interesting you point to the gap, Stuart, about the average African-American 12th grader being as prepared as the average white 8th grader. Martin Luther King, when he entered Morehouse, was reading at an 8th grade level. He was entering a world where Morehouse was quite capable of closing that gap. It's much harder to close that gap for any institution now based on how prepared you have to be, what kind of skills and knowledge base you have to have coming out of college to be gainfully employed. That change may be the biggest change of all. And I know that's part of what illuminates your emphasis on inputs, but we can't lose the focus on process and outputs. And that's an institutional responsibility.
Yeah,
Well,
I agree.
I'm sorry, Stuart, go ahead.
And one way to deal with the mismatch problem is that after students start at university, or maybe the summer before, you have remedial programs to close the gap. I think that there's something to that. I think the one thing we haven't talked about, which is, in my view, the idea that you have to have gone to a big-name, prestigious university to have a shot at success in this society, is badly outdated. I'd much rather have my child come out of Morehouse or, some relatively unselected place, you name it, with marketable skills, than come out of Wesleyan or Harvard, for that matter, with bottom of the class, lost self-confidence, and no marketable skills. And therefore, I think the presumption that generally goes in these conversations that, of course, you're better off being at the more prestigious place is really outdated. And I bet your graduates, the ones who emerge with good skills, do pretty well.
Well, I know that there are more questions, but it would be hard to beat that last interchange, so I think we're going to quit while we're ahead. And thank you all for coming.
All right. Enjoyed it?
Yes.
Oh,
good.
the books. The books, for those of you who are interested, there are copies of both Mismatch and So Rich, So Poor on offer outside. So if you haven't